This lecture is about the federal court system. And while we'll be talking about the federal court system, recognize that most state courts are organized in very similar ways to the federal courts, with the exception of the way the judges are selected. That varies from state to state. But in terms of how the judiciary works, many of the basic precepts are exactly the same because they're born from the Constitution and the um, British common law notion of law. The federal court system is a vital part of the three branches of government, a vital part of the checks and balances that we have been talking about throughout this conversation about American government. The court system is designed to interpret the laws. We used to say in law school that you don't know what a law says until a judge tells you what a law says, and that to some extent is true. The courts interpret the law and will declare laws unconstitutional under the concept of judicial review. The concept of judicial review, the judiciary reviewing the actions of the executive branch, judiciary actually reviewing the enactments of the legislative branch. That concept was formulated in the American democracy very early on. Now, if you look in the Constitution, there is nothing that talks about judicial review, but inherent in the court's authority is the authority to review laws to determine whether those laws are in keeping with the Constitution, and to review executive branch actions to see whether those executive branch enactments are in keeping with the Constitution, and whether those executive branch enactments are in keeping with the way the Congress wrote the laws. And so the concept of judicial review is alive and well, was born early in our democracy, and continues to be a vital part of our democracy. And it certainly is a vital part of the concept of checks and balances. The federal judiciary, like many state judiciaries, has a trial court division, and that trial court division is the district court. Now, why do I say it's a trial court division? Because in most state and federal court systems, there's a court in which you actually have a trial, the thing that you typically see on TV, where witnesses get to the stand and are able to tell, and where the lawyers have a chance to present their cases. That's the trial. And there's one division that handles the trial court, that you don't get new trials at every other level. In fact, if a new trial is ordered, it goes back down to the trial court division. There's only one court generally in every system that is designed for trials, for juries, and for judges, and for evidence to be brought out. And that's the trial court division. And in the federal court, that is the district court. Once an issue is heard by the district court, you then can appeal, but that appeal goes to the Court of Appeals, and it's often called the circuit court, because while trial courts, district courts are found in every state, and in a place like North Carolina, because of our size, we have three different divisions of the district court in the federal judiciary, and we have probably 50 or so in the state judiciary in North Carolina. You divide the state up into, the federal court divides the state up into three districts: the eastern, the middle, and the western, and they then have a trial court in each one of those areas. The trial court, again, has indeed what we would consider to be trial. They take on evidence. Well, after that evidentiary hearing, that evidentiary trial, then you can appeal if you are unsatisfied with the ruling or the decision of the jury and the ruling of the judge. You can appeal, and I say can appeal. Now, all appeals are not valid appeals. Therefore, while everyone can note an appeal, some appeals could get rejected because there's no issue that can truly be appealed on. There's no error done by the court, and the court will just say there's no error done by the trial court, and if there's no error, then there's nothing for the court to do. Recognize that at the appellate level, you're not getting a full bite at the apple again. You don't put on witnesses. There's no jury anymore at the appellate level, and you may not get a jury in the trial court. Depends on the kind of case it is. But you'll never get a jury in the Court of Appeals or the Circuit Court. You'll never get to put on new evidence. All the evidence that it will be looked at the appellate level must have been introduced at the district court level. So at the district court, at the circuit court level, the circuit court is going to hear the errors that you think that the trial court, the district court made. The circuit courts cover the entire United States, and they cover a series of states. We're in the Fourth Circuit, and that covers several of the southeastern states in this part of the country, and it has judges coming from every state within that circuit, and at least most of the time it does. Sometimes because of judicial appointments, that doesn't happen. The Supreme Court is the highest court in the land, and therefore cases are appealed ultimately to the Supreme Court, and certainly not a lot of cases. When you look at the volume of cases that go to the district court, it winnows down greatly when it gets to the Supreme Court of the nation. The head of the judicial branch of government is the Chief Justice of the Supreme Court. Currently, the Chief Justice of the Supreme Court is John Roberts, who heads that. And therefore, he will set forth many of the rules which govern the federal judiciary, which govern how the judges will conduct themselves, and govern the priorities for addressing cases, and how fast cases are moved through the federal judiciary. Now let's talk about the qualifications for being a judge and to be appointed a judge. The Constitution has no requirements, no job requirements for being appointed a federal judge. In essence, you can be a gas station attendant and be appointed a federal judge. In fact, in our history, we have had federal judges, Supreme Court justices, that did not attend law school. Now, that was back in the very, very early days of the nation, when you didn't have a lot of law schools, and when when lawyers tended to study under other lawyers to become a lawyer. But there's no even requirement that you're a lawyer in order to be a federal judge. Now, because they now have to be appointed by the president and have to be confirmed, even the district court judges, confirmed by the Senate, there's no likelihood that anyone other than a lawyer licensed to practice by some state bar is going to get to be a judge. And now I will tell you that in North Carolina, when I first started practicing law, you did not have to be a judge again you did not have to be a lawyer to be a judge. And in fact, we did have a number of judges that were not lawyers. I had the misfortune of practicing before a couple of them, and it would definitely come out. North Carolina does now have a constitutional provision which requires every judge to be a lawyer licensed to practice in the state. But the federal government does not do that now. But again, it'll never. I can't imagine a scenario in which someone not being a judge or a lawyer, I'm sorry, not being a lawyer, would become a federal judge. In fact, given that the current Supreme Court is going to be made up of 9 justices, 5 from Harvard and 4 from Yale, it's pretty apparent that you need to not only be a lawyer, but you probably need to be a lawyer from a substantial Ivy League school. And your best chance comes from Harvard or Yale. The judges are appointed for life or good behavior. Now, what that means is that judges, once a federal judge is appointed, they will stay a federal judge unless there is some reason to remove them from that. And that very seldom happens. I think you have an example of that happening in Texas. Before that, the only one that had happened in 100 years was Alcee Hastings, who was in Florida, and Hastings was impeached and then ran for Congress and was elected to Congress. The same people who impeached him, but the judge that was impeached in Texas had engaged in a number of improper sexual activities using his position to curry sexual favors and just was outlandish. But it's very seldom that a judge is removed. They stay on for life and then retire from their position. A judge to be removed has to be impeached, and they have to be impeached by the articles of impeachment are drafted by the House, and they then are voted on by the trial is in the Senate, and they're voted on by the Senate. Remember, the president appoints judges, and the president will appoint judges for all the district courts, which are in every state, and the Court of Appeals, and the Supreme Court. Now, the president doesn't appoint the state judges. State judges are a result of whatever the state mechanism is, and that can be elected like they are in North Carolina, or appointed and confirmed. There's just various mechanisms in every state to deal with the appointment of judges. However, the president appoints the federal judges, and he does so, or she does so, with the advice and consent of the Senate. You hear a lot of discussion about that because, again, these judges interpret the law. These judges sit for life. So as a result of them sitting for life, ruling until they are a 50-year-old has a 25-year lifespan on the court. So the presidential appointments have life well beyond the presidency. There are judges on the Supreme Court that were appointed by Gerald Ford. Just recently, a judge appointed by Gerald Ford stepped down from the Supreme Court. So you will have a presidency can last 20 to 30 years beyond the life of the term of the president, just merely because of the judges they appoint will still be ruling, and that judicial philosophy is probably going to be one that mirrors the judicial philosophy and the political philosophy of the president. The reason why federal judges are appointed for life is to remove them from the politics. Federal judges sometimes have to defend the Constitution during periods of national crisis and times in which the defense of the Constitution is very controversial. If you could imagine the federal judges in Alabama, Mississippi, and Georgia who indeed had to order school integration and other unpopular decisions, they would certainly not have been elected or re-elected to their judgeship if indeed the citizens of that state had to elect them at the time that they made those rulings. I'm not sure that the judges could have ruled in such a way, free and clear of the influence of the politics. In essence, why would a judge make a ruling that he knew would surely cause him to lose his job? That whether many judges would have the courage to do that, but many judges would not. Well, by appointing a judge for life, you don't have to worry about that. Every judge is appointed for life. They don't have to worry. They can make their ruling oblivious to the political whims of that day and whether their ruling is popular or not. Some would say that means that the judge is out of touch with the realities of the world. But however, what we are looking for is a judiciary that could be independent of politics, despite the fact that they arrived on the bench politically. And you do arrive on the bench politically no matter how it happens, whether elected or appointed. Despite the fact that they arrive on the bench politically, what we are looking for in a judge is a person who will put aside sometimes their personal political philosophy and interpret the law the way the law was written and intended to be interpreted. And that's why you have also the Senate confirmation on the federal bench, because you want to at least have some legislative check on the judicial power to make sure that the judge has a middle of the road judicial philosophy. And when I say middle of the road, I don't necessarily mean judges aren't going to be conservative or liberal. I mean, they're probably not going to be on any of the extremes. They're not going to be a radical left or radical right. When those kinds of judges get appointed, the Senate generally goes in and will not confirm them. One of the probably most recent examples of that is one Robert Bork, who had in his history written law review articles justifying segregation, saying Brown versus the board was erroneously decided. Well, the Kennedys of the world just weren't going to stand to confirm that kind of judge, and in fact, they in fact did not confirm him. The court is a vital part of the checks and balances of the U.S. government. Again, the U.S. government is designed to have checks and balances. We did not want to concentrate power too much into one section. So you have a president appointing these judges, so they have to be somewhat consistent with the philosophy of a president. You have a Senate confirming them so that they can't be too radical one way or another, so that they have to have some moderate leanings, at least enough to get past the Senate confirmation process. And then their role in the checks and balances is that they interpret the laws. While Congress may pass those laws, they interpret the laws. Now, and it's not unusual for Congress to write a law one way, the court to interpret it another, and Congress to have to come back and rewrite the law in order for it to say what they intended it to say. But they're going to interpret the law, and they interpret the law consistent with the Constitution. The judiciary will determine whether the acts of the executive branch are lawful, whether the executive branch has acted consistent with the law as it is written, or whether the executive branch has acted in an unconstitutional manner. They will interpret not only the actions but even the orders of the executive branch to ensure that they are consistent with the Constitution. The court will also interpret the laws of Congress to determine whether they have acted in a manner consistent with the Constitution. And so all of those are the court's way, or the court's role, in the checks and balances of our federal government system. The final role is that the Chief Justice sits as the judge in any impeachment of the president. So when Clinton was being impeached, the Chief Justice sat in on the impeachment of it. And this is why judges are very important. They rule on, they conduct the hearing, but really the the rules are not like a court in an impeachment. And so, but they do have some authority to rule here and there as things are being presented in that mechanism. That's not a role that they play many times, but it is a role that they play. There are the trial court division of the federal judiciary is called the district court. There are 94 district courts, and as I indicated, there's one in each of the 50 states, and attached to each one of those district courts is a bankruptcy court. The district courts is the trial court. You're going to hear witnesses, going to have evidence, motions, all those things that you typically associate with trial. But they're going to only hear cases about the U.S. Constitution, about federal statutes, or cases involving diversity jurisdiction. So typically, if you have a case that where you slip and fall in the in a local food store, no, that's not going to go to a federal district court, because that case is not a constitutional case. It is a tort case. It's not it doesn't involve the violation of a federal statute. It involves probably a violation of either a state statute or or maybe a common law. The only way it would get into the district court is if the store were owned by a corporation or entity that was a resident of another state, and then you could, by virtue of diversity jurisdiction, say I'm resident of North Carolina, they're residents of Virginia. I want it heard by the district court because I don't have faith in Virginia courts, or I don't have faith in North Carolina courts to hear this case fairly, and that's how diversity jurisdiction came about. But just a typical run-of-the-mill fender bender accident on the freeway, that's a state court matter. It doesn't go to a federal court because there's no constitutional issue and no federal issue. Now, anytime you have the state of North Carolina trying to take the property of someone, the state of North Carolina trying to incarcerate someone, the state of North Carolina trying to have a death penalty, those are constitutional issues, and those issues are going to be heard in federal court. A policeman who stops a person with no probable cause, that's a constitutional issue. So when the state is involved, or the city is involved, or a county is involved, yeah, you might have a good little number of constitutional issues that could be raised. And once you can raise one constitutional issue, even all the appending state issues will go along. And in those instances, the federal court will interpret state law as well as the federal law that has to be interpreted. And the same thing happens in diversity. If indeed you have two people from two different states and you're using the diversity jurisdiction to get it into the federal court system, then you would, in that instance, have have you apply the law of the state in which the incident occurred in most instances. And the courts would interpret that. Voting rights cases, civil rights cases, those are federal matters. You're interpreting a federal statute in those instances. However, I would say that you can take even those federal causes of action into state court. So you could have a voting rights case that you litigate in state court, or you could have a Title VII case that you litigate in state court, even though it is a federal action. And in many instances, the lawyers would always like to go to federal court because the federal judges were more liberal. But because now many of the federal judges were appointed by Reagan and Bush. In fact, the state courts judges are actually a little more liberal, and many people tend to bring things into state court, even though it may indeed be a federal issue. So it's sort of reversed from the 60s until now. In the 60s, you were trying to get into federal court, and now you're basically trying to stay out of federal court. There are also federal courts that are specialty courts. There are a number of specialty courts that exist. There's the International Trade Court dealing with international trade disputes, Federal Claims Court, which deals with disputes of citizens against the federal government, generally in some torts or property kind of manner, not constitutional kind of manner. And so there are a number of other specialty courts that the Congress has set up, not to take away the jurisdiction from the district court, but to help expedite matters so that these kinds of cases aren't clogging the docket of the federal district court. The first level of the appellate court, or the appellate division of the federal judiciary, is called the Court of Appeals, the Circuit Court of Appeals. And there are 12 regional circuit courts of appeals, that is 11 that encompass the states, and one circuit court for the District of Columbia. And so you've got 11 encompassing the 50 states that cover the 50 states, and one for the District of Columbia. You recognize, therefore, that more than one state is in a circuit. Each court of appeals, each circuit has a court of appeals, and it is comprised of judges that are made or that come from the states within that circuit. Court of Appeals hear the cases that are appealed from the district court within the states that comprise their circuit. So the Fourth Circuit Court of Appeals hears cases from North Carolina, because North Carolina and Virginia and a few other states are within the circuit that encompasses the Fourth Circuit Court of Appeals. The Fourth Circuit Court of Appeals does not include California. It will not hear appeals from a court case, a district court in California. The Court of Appeals also hears decisions of the federal administrative agencies. Federal administrative agencies sometimes sit in what we call quasi-judicial role, meaning they will hear controversies that come up as a result of one of their rules. a federal agency makes rules and they think that someone, environmental protection, for example, and they think that someone has violated those rules, and then they issue a fine, and they have a hearing in that federal agency. That federal agency will then conduct the hearing, make a decision, and the federal agency, or well, not the federal agency, but the person impacted by that decision can appeal, and they would appeal that case, since it has already been heard in terms of evidence. They would appeal that case to the Court of Appeals within that area. So if there's a NLRB, National Labor Relations Board issue because of a union, and you hear the NLRB then hears the case, you can then appeal that case from the NLRB to the appropriate Court of Appeals. And that happens with any federal agency that has a quasi-judicial function. You can appeal from their hearing of the quasi-judicial function of that agency to the Court of Appeals in the appropriate circuit. Again, on appeal, remember, you're not getting a full trial. You're getting now only a hearing about the errors that you think were made, errors in law or some constitutional violation. Some error in evidentiary ruling may even cause your case to be turned around. And in criminal matters, you could even argue ineffective assistance of counsel. There's also one special circuit, federal circuit, that deals with and they deal with these sort of special cases, patents, and some of these other special cases that come about. The highest court in the land is the Supreme Court. The Supreme Court, made up of 9 justices, hears cases from the lower federal courts, primarily the Circuit Court of Appeals, and it will hear cases from state courts when they involve a constitutional issue, generally, that needs to be decided, or a federal issue that needs to be decided, and there's some legitimate dispute about how that case should be decided. There are a few instances in which original jurisdiction starts in the Supreme Court. And when I say original jurisdiction, I mean where the Supreme Court actually acts as a trial court. And in those instances, cases involving ambassadors, controversies between 2 states, those are issues that would originate in the Supreme Court. There aren't a lot of those instances. I can't think of too many instances involving ambassadors, and in fact, there are very few instances involving controversies involving states. The one I can think of is New York v. New Jersey, fighting over Ellis Island, and whether Ellis Island was actually located within the boundaries of New York or located within the boundaries of New Jersey, and that was important for the purposes of I guess tourist dollars and to some extent. And then I think there's Arizona v. Colorado, which was a riparian rights, a water rights case. And there have been a couple of them involving North Carolina and Virginia, North Carolina and South Carolina with regards to water, rivers that run between the two states, major bodies of waters. And then I think the compact involving disposal of nuclear waste was threatened to go to the Supreme Court. But generally, states don't have disputes between them. Cooler heads generally prevail in those instances, but if they don't, then you can have original jurisdiction. Obviously, you can't hear a dispute between North Carolina and South Carolina in a South Carolina court. South Carolina is not going to want it heard in a North Carolina court. Where does it get heard? It can't go to the Fourth Circuit Court of Appeals because that's made up of people from various states, and they may be, in fact, could be made up of people who have more, one state may have more representatives than the other, and one state may not have any representative because you could be in two different circuits, even though they're neighbors. They could still be in two different circuits the way the lines are drawn. So the best way of addressing these matters is to let the Supreme Court serve as the court of original jurisdiction. Now that we know the role of the Supreme Court and how you are appointed to the Supreme Court and and the role of the lower courts in the federal judiciary and how you are appointed to those courts, and all are appointed the exact same way. Then the next question is now that we know that they're supposed to interpret the law, where does the law come from? What is the authority for the law? And the law basically comes from several places, and the primary authority for the law is the Constitution. Every law has to be subject to the Constitution. No law can violate the Constitution of the United States. And law can come in the state level from the state constitution, but even the state constitution cannot violate the federal constitution. The state constitution can give you more rights than the federal constitution, but it cannot give you fewer or less rights than the federal constitution. Law also comes from statute, and state and federal statutes can establish what the law is. Again, those statutes, a state statute or a federal statute, cannot violate the federal constitution, and a state statute cannot violate the state constitution. The Congress of the United States is not subject to the laws of the 50 states, and therefore the Congress of the U.S. can indeed pass a law which violates a state statute because they're not subject to that. But a state legislature cannot. The Congress can pass a law which violates a state constitution because they're not subject to that state constitution. However, a state legislature cannot pass a law that violates its own state constitution and cannot pass a law that violates the federal constitution. The judicial decisions also is a source of law. In the British jurisprudence and United States jurisprudence, and the British, I say British jurisprudence because the United States was a colony of Britain, our judicial tradition generally is from the British tradition, and inherent in and a major part of the judicial tradition of the United States and Britain is the concept of stare decisis. And stare decisis, and that's S-T-A-R-E-D-E-C-I-S-I-S. Stare decisis is a concept which says we are going to follow the precedent set down by other courts. We're going to follow the decisions of other courts unless we have a legitimate reason to change the precedent, to change the judicial thinking at this time. The concept of, and therefore the concept of stare decisis means that the law can come from other judicial decisions. Common law is basically judge-made law, judicial decisions handed down earlier, where judges have crafted solutions to issues, and now other judges have decided we will follow that judge's decision. And what that does is it keeps the law stable. It means the law is predictable because I can now look at the way other judges have decided it and decided a similar case and decide and determine how they're going to determine in the case that I have, and that is and that keeps the stability of the law and makes it easier for lawyers and business people to predict how the court is going to behave. So the concept of stare decisis, or in essence, the law can come from other decisions that a judge has made. There's one other place that the law comes from that isn't mentioned on the PowerPoint, and that is it can come from rules promulgated by federal agencies. And federal agencies all promulgate rules. State agencies promulgate rules. Those rules govern the conduct of any entity, any person or corporation or other business entity that engages in conduct that's subject to those rules. So the reason you just can't dump grease down the drain pipe is because there are various rules and laws that back those rules up that make that a violation. And so many of your environmental regulations are indeed regulations, rules promulgated by the Environmental Protection Agency or by a state agency. And that is a source of law, and that has the same impact. As state personnel director, when I established the rules on holidays and on vacation, that has the same impact as law. The rules governing how state employees are terminated has the same impact as law, and the court will then have to apply those rules as they're interpreting the case about a state employee. So you have federal agencies promulgating rules, and you have state agencies promulgating rules, and those can be a source of law. We must, however, keep in mind that there's a hierarchy in the law. The rules promulgated by a federal agency cannot violate federal law and certainly cannot violate the Constitution of the United States. Rules promulgated by a state agency cannot violate state statute, cannot violate federal statute, cannot violate the state constitution, and cannot violate the federal constitution. There's also a secondary source of legal authority. Now, these secondary authorities don't carry nearly the weight of the primary authorities that I just cited: the Constitution, statutes, judicial decisions, and agency rules. These secondary authorities are things like treatises, law review articles. These are writings of legal thinkers that talk about the way the law should be interpreted, and in essence look at the law geared against the public policy, the intent, the legal history, and then make suggestions as the way the law should be interpreted. Courts are not governed by that. They do not have to look at that at all. In fact, the only time you generally use that is if you don't have a primary authority. You don't need a law review article or a treatise if there's a primary authority on it, if there's a prior court decision, if the rule is on your side, if the statute is on your side, or the Constitution is on your side. There's a little saying in the law: when the law is on your side, pound on the law. When the policy is on your side, pound on the policy. And when neither the law nor the policy is on your side, pound on the table. Well, when you're doing treatises and law reviews, you're just above pounding on the table. Now that you know where the law comes from, you must also know that all law does not apply in all courts. So, for example, all courts are bound by the rulings of the Supreme Court. The rulings of the Supreme Court are stare decisis on any matters that come before any federal court and any matters that come before a state court, meaning all district courts, all circuit courts of appeals have to comply with the Supreme Court order of Supreme Court of the United States. The Supreme Court of the various states that Supreme Court is the highest court in that state's jurisdiction, and all state courts in that jurisdiction must comply with the rulings of the Supreme Court of that state. However, federal courts in that state are not bound by the Supreme Court of the state unless it is about a matter of state law. Federal courts will comply with the Supreme Court of a state if they are trying to make a decision that is found in state about an issue of state law. Then they will then follow that state court's Supreme Court. And that's any federal court. Even the Supreme Court of the United States will defer to a state Supreme Court's opinion about that state's law. However, the at the lower level, when you're talking about an opinion of the circuit court, the Federal Circuit Court of Appeals, then those opinions are law, and the lower courts in that circuit are bound by that. So the district courts in the Fourth Circuit Court of Appeals, or the district court has to follow the opinion of the circuit court that its cases are appealed to. The state courts will have to follow that also, to the extent that it is interpreting issues of federal law that may be applied in the state. It would not have to follow that court's opinion to the extent that it is interpreting state law, because the state law is going to be governed by the state court of appeals or the state Supreme Court or some higher level. Circuit courts do not have to follow other circuit courts. So one federal circuit court can decide a point of law one way. The other federal circuit court can decide a point of law in the exact opposite way. That is typically the kind of case that ultimately will get to the Supreme Court when there is a division amongst the circuits. So the circuit court opinions of one circuit are persuasive and can be used to argue a case, but they do not have to be adopted by the other circuit court. All of these rules about which courts apply to which court, though which laws apply in which court, are come out of a concept called stare decisis. It's STAREDECISIS. That is a doctrine of the law which says, it's a legal principle that says judges will be obliged to obey the precedent established by other courts of higher authority. The first rule that about stare decisis is that superior court or higher courts are binding on lower courts. The second principle is that courts should not overturn. A court is not bound by its own rulings. So the Court of Appeals can overturn its own rulings. But the notion of stare decisis not only says I have to follow the higher court's opinion, but the notion of stare decisis also says that I must not take lightly the prior opinions of a court of the same court that I'm in, the Fourth Circuit Court or the Supreme Court. And so you try to keep the law stable so that you're not, so that people know what it is. And so you're going to use precedent to keep the law stable so that you're not going to just overturn and make a decision which is opposite of one that was made previously. As you will see, however, courts do overturn their prior decisions. As you will see in confirmation, particularly of Sonia Sotomayor, she's asked about that. And the Plessy versus Ferguson established the doctrine of separate but equal. Brown versus the board came back and reversed that doctrine, said separate is inherently unequal. Basically, the court reversed itself. And so courts do reverse themselves as times change. But basically what we're trying to do is keep the law stable so that people know what the law is, but it also gives enough flexibility for courts to at least modify their interpretation of the law as it becomes clearer to them, and as the context may change. But when you have something called a landmark decision, it is basically because either they're changing a precedent or that they have entered a new issue and a new doctrine has been set forth. But courts, many people complain saying courts are activist courts if they go in and they're changing a lot of precedent. But virtually every court is an activist court. Every court makes the Supreme Court doesn't make decisions that aren't somewhat novel. If they were ordinary, they would be resolved by the other courts. So every court is activist, and so that distinction really is a distinction that probably only turns on where you sit. If I don't like what the court did, it's an activist court. If I do like it, they're just being loyal to the founding fathers' doctrine.
Does that mean that the Supreme Court should perhaps be even more cautious, even more self-restrained, since there is no appeal from any errors that they might make?
I think that's a solemn responsibility that they have. When you know that you are the court of last resort, you have to make sure that you get it right. It is not true, in my judgment, that the Supreme Court is free to do anything that it wants. It has to follow the Constitution, and it has to follow the laws. Stare decisis, which I was talking about earlier, is an important limitation on what the Supreme Court does. And although the Supreme Court has the power to overrule a prior precedent, it uses that power sparingly, and rightfully so. It should be limited in what it does.
Told us that you will follow the law and follow precedent, and you've made a very big point of this, and that's all well and good. But some of the court's most important landmark rulings overruled long-standing precedent, like Brown versus Board of Education, which ended legal segregation. Now, as an appellate judge, as we know, you're required to always follow precedent, but as a Supreme Court justice, you will have the freedom to depart from precedent. So tell us how you will decide when it is appropriate to alter, amend, or even overrule precedent?
The doctrine of stare decisis is a doctrine that looks to the value in the stability, consistency, predictability of precedent. And it starts from the principles that precedent are important values to the society because it helps those goals. It also guides judges in recognizing that those who have come before them, the judges who have looked at these issues, have applied careful thought to the question and viewed things in a certain way, and a judge should exercise some humility and caution in disregarding the thoughts and conclusions of others who came in that position before them. But that's not to suggest that the doctrine says that precedent is immutable. And in fact, I believe that England had an experiment with that question, and it was not horribly successful. Precedents are precedents. They're not immutable. They have to change in certain circumstances. And those circumstances generally, as have been described by Justice Souter in the Casey case, are probably the best articulation people have come to in sort of talking about the factors that courts think about. And